Hello and welcome. I'm Peter Afrasiabi. I'm the host of the Curious Lawyer series. The Curious Lawyer is a fun, interesting, educational, entertaining, edutainment, you could say, walk into different areas of the law that you may not intersect within your practice, but from which you can learn from and even find good metaphors at times to use in your practice. It allows us to explore those little areas of the law that you don't get to see in your day-to-day practice, but are really fun and exciting and interesting when you're not wanting to do CLE in the technical, perhaps sometimes boring areas of your practice. So, in the Curious Lawyer series, we've looked at CIA law. If you ever want to understand where those I cannot confirm or deny phrases come from, it turns out it comes from a lawyer practicing with the CIA. You can learn all about that there. We've looked at dog law to see how our favorite furry creatures intersect with the law in all sorts of different areas. We've even looked at Yellowstone and if there's a zone of crime where you could get away with a perfect murder. And we've looked at the music of U2 to explore some copyright law by listening to U2 music and exploring all different aspects of copyright law. So there's a whole range of programs in the Curious Lawyer that expose you and educate you in different areas of the law. Today, of course, we're looking at Supreme Court secrecy, shadow dockets, leaks, and cameras. We've all been hearing more and more, especially after the leak of the opinion reversing Roe v. Wade, about Supreme Court secrecy. And so this program today lets us look at the issues that are animating the current secrecy situations, at the U.S. Supreme Court in terms of shadow dockets, in terms of how they resolve cases, these leaks, and cameras in the courtroom. So we're going to start on these secrecy topics by exploring exactly what is the shadow docket. How does it work? What is it doing? What's going on? And we're going to look at some case examples from immigration to abortion to death penalty, all in the context of injunction rulings, looking at the familiar four factors for an injunction: likelihood of success on the merits, irreparable harm, balance of hardships, public interest, those types of factors. But we're going to look at these as decisions when the Supreme Court gets a hold of these cases and what it's doing with them and the impact this is having. And so we will traverse from the 1970s, where literally you'll see lawyers hiking into the woods to try to find Justice Douglas to issue a ruling, to the 1980s and rule reform, taking it out of the hands of individual justices and putting it before the court, into the 2000s, where we have started seeing an increasing use of what's known as shadow docket rulings to really expand and resolve and create what are seemingly precedential cases at times. And this, of course, will allow us to look at the legal issue of, are these shadow docket rulings really precedential, and the huge lower court confusion in terms of what to do with them. And we can see this from some of the same-sex marriage cases that were going up on injunctions all the way to immigration cases today. So after the shadow docket, we're going to look at some of these leak issues and the secrecy stuff that comes out of that. And we're going to specifically look at the Roe v. Wade reversal leak issue that you probably all remember from 2022, where many months before the decision came down reversing Roe v. Wade, there was a leaked opinion that came out and hit, the airwaves, and we all sort of had a sense of knowing what's going to be coming. And this big leak issue triggered, a net of suspicion and surveillance and investigation by the Supreme Court marshals into who did it. And we're going to look at the history of actually some various leaks in Supreme Court cases, the secrecy rules that exist, and possible legislation, along with some First Amendment cases on courts and secrecy and the level and really extent to which we can have secrecy in courts and where the boundaries are on this under the existing law. Finally, we're going to look at cameras in the court, Supreme Court, their secrecy, public transparency needs, and the amazing thing that happened, one of the, positive things, I guess you could say, for the law that came out of COVID and the horrendous emergency situation that hit the country was the fact that the U.S. Supreme Court was forced to open up and have real-time audio broadcasts of their decisions that we can now listen to in real time, and also get same-day audio and transcripts of the cases. And so we'll look at that along with the hilarious flush in time that embarrassed the Nine when one of them flushed their toilet on one of the early oral argument cases during the COVID pandemic. And we're going to look at the now current post-COVID standards and pending legislation that's actually out there to force and legislate a reduction of this kind of secrecy regime that's been created by the Supreme Court to create more transparency. And so the ultimate question we're left with throughout this program is, should there be more transparency into the Supreme Court, or should there be less? And these pending rules that are out there to perhaps punish leaks, to create more cameras, really get at different aspects of the secrecy question in terms of, are we reaching a point where, especially with technology, we're not going to tolerate this kind of hyper-secret, cloistered group that we've had in the past? And are we going to go into a new bold future where there's less secrecy? And as you'll see as we look at the history, that bold new future may actually look like a lot like the ancient past. Let's get started in our first module on the shadow docket. What is it exactly? First of all, the phrase is a term that was coined by a law professor, Professor Bowd, in 2015. And it basically refers to the Supreme Court's docket that issues rulings on procedural matters related generally to injunction orders from lower courts or scheduling issues. And the basic point is that the Supreme Court, of course, has an emergency docket. And it gets rulings that come up, and then it issues opinions on those rulings, and these are often like emergencies, like injunctions, and you get a fast turnaround of a ruling. And as a result, it does not have extensive briefing, there's no oral argument, there's no amicus briefs, and the rulings just get issued. And this sometimes includes just summary reversals of lower court opinions. Now, the contrast is what we're all familiar with, and this is the Supreme Court's merits docket. And these are the cases that are ordered for full briefing, where you have, massive briefs filed, endless amicus briefs filed. You have a lengthy oral argument that's public that we can listen to, and then you get endless numbers of opinions from the Supreme Court with all their concurrences and dissents and you name it. So the other thing that adds a little bit of intrigue to the shadow docket is often these orders that come from the Supreme Court on these non-merits cases, these procedural type rulings, and injunction things are often issued at night, sometimes on Friday nights, and this just adds a little bit to the intrigue afoot in terms of understanding, who are issuing these orders, what's really going on. So let's take a look on our next slide here at the SCOTUS, the Supreme Court of the United States rules as it relates to shadow dockets. Now, under the old rules, an emergency request would go to one justice who was responsible for a given circuit or region, and that's sort of the way things were up through the 1970s. But in the 1980s, the Supreme Court adjourned, and this was in its summer session, when it was literally adjourned, and so each justice was responsible for a different region. But in the 1980s, the Supreme Court actually ended this practice of formally adjourning court for the summer. And that then allowed the justices to decide issues as a court in unison rather than by an individual justice just kind of being responsible for his or her region while the court was literally adjourned. Now, in these cases, there are no oral arguments. Now, there's no rule that requires or disallows it, but the custom has been there's just no oral arguments held, although we'll see one funny exception in a moment. And so these cases ultimately then are resolved on very limited briefing, without arguments, without amicus opportunity, and orders are issued. And they're on often injunction questions. And the question then is, are these rulings only applicable to the two parties before the court on it, or are they becoming broader and broader and becoming presidential decisions that are now starting to bind lower courts where they're being issued without full briefing, without argument, without the scrutiny that we expect of the 70-odd cases the Supreme Court decides every year. Now, here's what Professor Stephen Vladeck spoke and said to Congress when he spoke in hearings looking at the shadow docket and whether Congress needs to do something to get involved here to start curtailing the use of this docket or limiting how and what the Supreme Court can do when it receives these types of cases. And here's his quote. Owing to their unpredictable timing, their lack of transparency, and their usual inscrutability, these rulings come both literally and figuratively in the shadows. This is part of the reason it's been referred to as a shadow docket. These decisions just creep out of the shadows, out of nowhere it seems, and can create a whole bunch of mess in the circuit courts, as we will look at. So let's take a look now at some shadow docket cases, and we're going to look. The first one is a Justice Douglas case in 1970, and this is when this court was adjourned for the summer, and so, if you had an emergency injunction type issue, it'd go to one justice who would issue a ruling. And so here are the facts in Dexter v. Shrunk from 1970. There were protests going on in Portland that summer, and they were occurring, and a local policeman was accused of using really violent tactics to suppress the protests. And so an injunction was sought to, put some controls on the police and the violence that was being used. The injunction was denied, and so an emergency petition was filed to the Supreme Court. Now, we're in summer, and so this emergency request needed Justice Douglas's attention because he was supervising the Ninth Circuit. But it turned out he was on vacation in the woods. And so apparently, as legend has it, the lawyers for both sides hiked out 6 miles to his remote, cabin or camp, wherever he was staying. He actually held an impromptu oral argument, and apparently he then left his handwritten decision on a tree stump. And so here you can actually see there is quite literally a copy of his handwritten decision that he issued in 1970 on August the 29th in summer, apparently after hearing this woods-based impromptu oral argument from the lawyers. And here he hand-wrote, under Dombrowski v. Feister, petitioners make out a strong case for federal protection of their First Amendment rights, but Dombrowski, a 5-4 decision decided in 1965, is up for re-examination in cases set for argument this fall. If the present case were before the conference, I am confident it would be held pending the cases to be re-argued. Hence, as Circuit Justice, I do not feel warranted in taking action contrary to what I feel the conference would do. Accordingly, I deny the restraining order requested. So he didn't get involved. He wasn't willing to mess around and really wanted to wait for the full court, as you can see on that handwritten decision in 1970. Let's now take a look at the more modern era, and we'll go to 2014, and we'll look at a death penalty order. And this is the case of Ryan v. Wood. You can get this death penalty very, very short order decision at 189 Lawyer Edition 2nd, 873. Again, it's from 2014. And so here are the basic facts. Wood had been convicted and sentenced to death for the 1989 murders of his estranged girlfriend, Deborah Dietz, and her father, Eugene Dietz. Now, Wood was seeking information on how he was going to be executed by the state, and he wasn't given it. And so he had argued, he'd filed litigation in the federal courts, that the act of withholding this information explaining the method that was going to be used to execute him violated his First Amendment rights. And this, of course, was, we're now in 2014, so of course this is many years after the original murder conviction trial. He'd exhausted all of his other appeals and all that, so all of the death penalty decision had been put to bed. Now it was just this new piece of litigation over his claim that he had a First Amendment right to access the information in terms of how he was to be executed. So this went up to the Ninth Circuit, and the Ninth Circuit granted an injunction enjoining the execution from being carried out. And you can read the opinion at 759 F. 3rd, 1076. It's from the Ninth Circuit in 2014, and it was a split decision, a 2-1 decision. There was a dissent. This prompted an en banc call by then-Judge Kaczynski, who said that lethal injections were a misguided effort to mask the brutality of executions, and he sort of implied firing squads should be reinstituted. Quote, "Sure, firing squads can be messy, but if we are willing to carry out executions, we should not shield ourselves from the reality that we are shedding human blood." End quote. In any event, he called for an en banc ruling. It didn't happen. And so then, after this sort of, and he published an opinion, there was other published opinions on the denial of en banc in the Ninth Circuit. So you've now got a split Ninth Circuit panel decision. You've got published en banc dissents going out. And so you got a bunch of published opinions coming out of the Ninth Circuit on this question of whether an injunction could or could not issue under the First Amendment, staying the execution because the state had violated the First Amendment. This goes up to the Supreme Court of the United States, and it simply issued an order vacating the stay. No explanation was given, and hence the execution was carried out. And so that's an example of how these shadow docket decisions are being issued in this day and age. We have no idea why the stay was vacated because there was no explanation given. We don't know what exactly was wrong about the Ninth Circuit's opinion. We don't know if they were agreeing with Kaczynski, agreeing with dissent in the Ninth Circuit, partially agreeing with the majority in the Ninth Circuit, but perhaps not agreeing with majority on another decision. We just don't know because it was just a vacated order without explanation. So this is an example then of, in real practice and in the real world, how this shadow docket is playing out without transparency, understanding. And this is an example of a death penalty case on sort of a massively, important, complicated issue, one that spawned conflicting judicial opinions below, yet we don't know how anyone on the Supreme Court felt about it, and we don't even know how the Supreme Court voted. Was it unanimous? Was it 5-4, 7-2? We just have no idea. And so this is sort of what has started this process of more and more conversation about the shadow docket and the troubling nature of it because of the lack of transparency into what's going on. Now let's take a look at our next case, and this is from 2020. This one's called Roman Catholic Diocese of Brooklyn versus Cuomo, 141 Supreme Court 63, and again from 2020. Here are the basic facts. This is a COVID case. There was a New York state law that was enacted post-COVID that put capacity restrictions on religious worship houses. You all may remember a lot of these laws in different states were being issued at the time of COVID when the pandemic began. In any event, restrictions on the number of people who could be in houses of worship were ordered by the New York State, and this was then challenged, and the lower courts upheld the restrictions, finding that those were legitimate restrictions, even though they were in houses of worship, which people have a First Amendment right to attend. These were the time, place, manner type restrictions given the pandemic that were legitimate and appropriate. And so in any event, the restrictions are permitted in the New York courts. This goes up to the Supreme Court, and the Supreme Court struck down the New York state law restrictions. And this time we actually had no oral argument, no extensive briefing on these really important First Amendment issues, but we did get an actual explanation this time of a decision, and we had a dissent. And the majority said that the applicants have clearly established their entitlement to relief pending appellate review. They've shown that their First Amendment claims are likely to prevail, that denying them relief would lead to irreparable injury, and that granting relief would not harm the public interest. Pretty thin. The dissent said they may restrict attendance at houses of worship so long as comparable secular institutions face restrictions that are at least equally as strict. And so that's really what you have. It doesn't really help a lot in future cases for lower courts, other than looking at it saying, I guess those types of restrictions are okay or not okay since the Supreme Court struck them down, even though we don't have a deep analysis and we've got a paucity of understanding in terms of what exactly was happening and how this came about. Let's go to another shadow docket case from 2022. This is Merrill versus Milligan. And here are the basic facts. This is a voting case. So Alabama redistricted its voting boundaries. This then was challenged in court, and the lower federal court proceeded to hold a 7-day hearing, looked at thousands of documents. This was done by a 3-judge panel, which is done in these voting redistricting boundary cases under the Voting Rights Act. And the 3-judge panel, after its 7-day hearing with witnesses and documents and all the like, concluded that Alabama's redistricting plan violated the Voting Rights Act because it was discriminatory against black voters. And so this 3-judge panel, after that hearing, issued an injunction. This goes up to the Supreme Court, and it doesn't get subjected to oral argument in the merits briefing. Instead, the Supreme Court, using the shadow docket, simply stayed the injunction. In other words, reversed this 3-judge panel after its hearing, trial. And we get a dissent this time that says, today's decision is one more in a disconcertingly long line of cases in which this court uses its shadow docket to signal or make changes in the law without anything approaching full briefing and argument. Here, the district court applied established legal principles to an extensive evidentiary record. Its reasoning was careful, indeed exhaustive, and justified in every respect. To reverse that decision requires upsetting the way Section 2 plaintiffs have for decades, and in line with our case law, proved vote dilution claims. That is a serious matter which cannot properly occur without thorough consideration. Yet today the court skips that step, staying the district court's order based on the untested and unexplained view that the law needs to change. That decision does a disservice to our own appellate processes, which serve both to constrain and to legitimate the court's authority. And so you can see a pretty sharp dissent here, noting this use of the shadow docket is skipping the process, it's undoing the law, it's creating now significant, perhaps, wrinkles in the law, changing existing case law, which starts creating questions about precedent, and is this now precedent, all without the normal appellate process being employed. And so it's a very, very powerful way to do massive changes in the law to a Voting Rights Act situation, for example, after a complex evidentiary hearing had been held, without really any transparency or scrutiny. And so the dissent was extremely unhappy, as you can see in this case. Now we'll go to Louisiana versus American Rivers, again a 2022 case. And this was a case where the Trump administration had issued a regulation that was preventing states from blocking infrastructure products that could contaminate rivers, lakes, and streams. And so basically, whatever power states had to put a halt to projects due to potential environmental damage to rivers, lakes, or streams, that power of states to halt those infrastructure products where potential damage existed had been placed on hold by the Trump administration's regulation. So this went to the district court, and the district court said no. The administration doesn't have the right to freeze states' rights when it comes to controlling internal infrastructure projects within the states, and they're addressing these kinds of risks. And so that district court injunction went up to the Supreme Court, and it hit the shadow docket because it was an injunction appeal. And the Supreme Court voided the injunction. It stayed it. It gave no explanation. And so as a result, that President Trump's administration, that regulation that had been issued, was now reissued, so to speak. It was no longer voided, and it just stood. And there's no explanation given for why the district court got this wrong, what the district court did wrong, where it went wrong in its analysis, what perhaps should be done if this gets challenged in another district court. We just had it, the injunction being voided without explanation. And so here we have yet again a dissent in the Supreme Court. This time the dissent says, by nonetheless granting relief, the court goes astray. It provides a stay pending appeal and thus signals its view of the merits, even though the applicants have failed to make the irreparable harm showing we have traditionally required. That renders the court's emergency docket not for emergencies at all. The docket becomes only another place for merits determinations, except made without full briefing and argument. I respectfully dissent. And so this is where it becomes really interesting, because what's going on is when we are dealing with appeals, where one of the factors is likelihood of success on the merits, and the Supreme Court jumps into that and without explanation takes a position on it, and then also agrees to hear the full appeal, in essence what the dissent was saying is, before even getting the briefing, you've signaled where you stand on the merits of the likelihood of success and where the law is going to land on this. And we are sort of playing a game of hopscotch almost and getting, well ahead of ourselves, or, using the other metaphor, getting over our skis, so to speak, in this use of the shadow docket. So let's look at another case, and this was sort of the demise of Roe, and this is where we may actually have shadow docket foreshadowing even going on. And so the case ultimately that we'll talk about in a little while, about when we get to another aspect of this program in terms of leaks, is the Whole Woman's Health versus Jackson case from the U.S. Supreme Court, and that's the case, of course, that came down and ultimately reversed Roe. But before that case came down, and before it was even leaked in its kind of leaked opinion form, we had a case going up to the U.S. Supreme Court on an injunction coming out of this case. And so if we peel back to the underlying facts, we can remember what this whole thing was about that led to the whole underlying battle. So the basic facts were that Texas enacted a law prohibiting all abortions at 6 weeks, and it allowed the population basically to enforce the law. Now, this facially violated existing abortion law, Roe v. Wade, because banning abortions at 6 weeks was a facial violation of Roe, which didn't allow the state to just outright ban them in the first trimester, as you all remember from Roe v. Wade. And so the district court simply enjoined the law and said, no, the Texas law is unconstitutional under Roe v. Wade. Now, this went up to the Supreme Court on an emergency appeal of the injunction before the full merits issues obviously were to be addressed about Roe v. Wade. It was just simply under existing law, can the district court enjoin the Texas law because it facially violates existing Supreme Court law, Roe, Casey, the like. This goes up to the U.S. Supreme Court, and on the shadow docket, the Supreme Court simply vacates the district court's injunction and allows the Texas law to take effect. Now, this provoked two big dissents, one by Justice Roberts and one by Justice Sotomayor. So let's take a look at Justice Roberts' dissent. He would keep the injunction and allow more development. And the quote was, "But although the court does not address the constitutionality of this law, it can, of course, promptly do so when that question is properly presented." In other words, he's saying, we're not addressing it right now, but we can in the future. And so that's the appropriate time to address it, when we get the merits appeal. And at such time, as he goes on, the question could be decided after full briefing and oral argument with consideration of whether interim relief is appropriate should enforcement of the law be allowed below. Now we see Justice Sotomayor's dissent, which is passionate. The court's order is stunning. Presented with an application to enjoin a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, a majority of justices have opted to bury their heads in the sand. Last night, the court silently acquiesced in a state's enactment of a law that flouts nearly 50 years of federal precedent. So you can see Justice Sotomayor was greatly disturbed because, as she said, this is a flagrantly unconstitutional law under existing law, and until we get the case on the merits and reverse it, we have to follow existing law. But on the shadow docket, the Supreme Court refused to and simply vacated the law. And so at some level then, what we saw when that, shadow docket ruling was issued was we're probably getting some foreshadowing that, Roe v. Wade is going to be reversed ultimately. As we all know, ultimately then, in fact, did happen with Whole Woman's Health versus Jackson. So what now is going on is this use of the shadow docket when we're looking at injunction orders and issues and the factor on injunctions of likelihood of success on the merits, we're now getting kind of preliminary rulings almost in terms of them saying this is where we're going to land on this ultimately. And that is of great consequence because it's not done with full briefing, with oral argument, with amicus briefs, and indeed they may not always get the case on the merits. There could be other reasons. The case could go away for another reason. And so when we get these decisions on injunctions without explanation and then perhaps no merits decision, stones have been thrown in the pond, and there's a lot of ripples that come from that can affect lower courts who then get similar cases and are trying to figure out, yikes, where is the law here? Here's some data from 2021 on the Supreme Court's shadow docket. They issued 66 orders from the shadow docket in 2021. 5 of those cases went on the normal docket for full briefing and argument, including some of the vaccine cases, the Texas abortion case, and a capital case that has some religious issues to it. And so you can see here sort of some really just interesting data, really, just to look at the types of cases that are hitting this shadow docket, how they're being decided resolution-wise, where we're getting dissents from them from all sides of the political aisle. It's a really kind of interesting little piece of data and a slide for you to look at. Now, one of the questions we've talked about here is, what do we do with these shadow docket rulings? They're sometimes very, very thin. It's just, order, injunction vacated, you get a dissent sometimes, maybe not even that. What do you do with that? Sometimes there's a little more detail given. The question then is, what does this mean for lower courts? Because a ruling on an injunction requires a preliminary assessment of the merits. The Supreme Court's done that. The question then is that binding on later courts, lower courts, district courts, or appellate panels, who may then later be addressing the same issue, but after the factual record is further developed? Because remember, these cases are going up on a preliminary injunction record. What happens when more development's made, or where more law is looked at in a slightly different way? Is this supposed to be just a preliminary pre-full record development, or is it not? And so if the Supreme Court, though, being the Supreme Court, has said, we think this injunction shouldn't stand, even if that's a preliminary assessment of the law, what does a lower court panel do with that? I mean, does a lower court panel just ignore it and say, well, look, it was an injunction ruling, it doesn't count? Or does a lower court look at it and say, yikes, even though they didn't look at everything and give us detail, I know enough to know that they're a higher court and they kind of think the law goes the other way, so I got to look at the law and try to figure out what to do with that and how to harmonize what I'm reading in the case law with what at least is kind of big picture, the word being told to me that the law probably goes the other way, right? This creates really complex precedent questions. And so we can look here at one where this has come up in the Fourth Circuit in the immigration context. And here we have Casa de Maryland versus Trump from August of 2020. And basic facts are as follows. Immigration law said that aliens who could be public charges can be deemed inadmissible. And so the DHS instituted an immigration rule that anyone who was likely to receive any kind of public benefits would be a public charge and therefore inadmissible. And so lawsuits were filed to enjoin that rule. 2 circuits, and the rule was enjoined, 2 circuits affirmed the injunction, but a third case went to the Supreme Court and it then undid the injunction and just issued a shadow docket ruling saying, nope, injunction vacated. So the case then goes up to the Fourth Circuit, and the Fourth Circuit's trying to figure out what to do. What do we do with this? Because SCOTUS has undone an injunction. Other circuits have affirmed injunctions. We now have a case. And so here you see a majority and a dissent in the Fourth Circuit struggling with what's the precedential value of that shadow docket ruling. Here's a majority. We may, of course, have the technical authority to hold that, notwithstanding the Supreme Court's view. The plaintiffs are likely, after all, to succeed on the merits of their challenge. But every maxim of prudence suggests we should decline to take the aggressive step of ruling that the plaintiffs here are, in fact, likely to succeed on the merits upon the heels of the Supreme Court's stay order, because that necessarily concludes that they were unlikely to do so. Such a step would require powerful evidence that the Supreme Court stay was erroneously issued. The dissent, on the other hand, says, in my view, assigning significance to perfunctory stay orders is problematic. Decisions rendered pursuant to emergency stay requests force the court to consider important statutory and constitutional questions that have not been ventilated fully in lower courts on abbreviated timetables and without oral argument. Accordingly, the court's stay orders do not control the evaluation of the merits of the preliminary injunction at issue in these proceedings. So you can see huge debate between the majority and the dissent here over if this is precedent at all, and even if it's not precedent, should, as the majority was saying, the maxim of prudence indicate that they be careful and look for kind of powerful evidence to overcome what the Supreme Court has signaled. Here's another case coming out of the Ninth Circuit, and this comes out of the same-sex marriage cases going back to the kind of first 2000s and 2010, 12, 14 in that time zone. And basically, we had lower courts were starting to issue rulings authorizing same-sex marriages after law changes. And in one of them, the Supreme Court of the United States stayed a Utah federal court order that had been issued on the court's shadow docket, and that was the shadow case of Herbert. So the Ninth Circuit now confronted a similar state law authorizing same-sex marriages. And so what's the Ninth Circuit to do in light of the shadow ruling? And here you have Judge Hurwitz stating, quote, when this went up to the Ninth Circuit, although the Supreme Court's terse 2-sentence order did not offer a statement of reasons, and although the Supreme Court's order in Herbert is not in the strictest sense precedential, it provides a clear message. The court, without a noted dissent, decided that the district court injunction against the application of laws forbidding same-sex unions should be stayed at the request of state authorities pending Court of Appeals review. So that triggered confusion. Now, other courts refused to treat it as precedent. You've got this Fourth Circuit case and McQuigg versus Bostick and Bostick versus Schaefer. So confusion in the lower courts over what to do. Congressional reform. In 2021, the House actually held hearings on this shadow docket and all agreed, bipartisan, they wanted reform. The concerns were it's affecting the court's perceived legitimacy given the lack of clarity for who voted on what. These short, unclear decisions are very hard for lower courts to follow. And so here you have a couple quotes, as you can see, from Democrats and Republicans I gave you, just showing the bipartisan nature of each demanding, we want transparency fundamentally in the process. And that's what's very, very clear coming from that bipartisan bill that is pending, hasn't passed yet, but we will see. So this brings us to our next module, which is secrecy in the Supreme Court. And the current nature we have and understanding in our 21st century interaction with the Supreme Court is it's this sort of cloistered secret bunch. But let's actually take a look at history and see how this has been since the beginning. The founders were very clear that matters of courts were of significant public concern. And so here you just have a quote from Adams, and you can get the quote from that archives.gov link that I've given you. But it's, liberty must at all hazards be supported. Liberty cannot be preserved without a general knowledge among the people who've got a right to, from the frame of their knowledge to knowledge of the characters and conduct of their rulers. Rulers are no more than attorneys, agents, and trustees for the people. And if the cause, the interest, and trust is insidiously betrayed or wantonly trifled away, the people have a right to revoke the authority. This idea, right, is critical to sort of what was in the minds of the founders. And so that's why, quote, and the preservation of the means of knowledge among the lowest ranks is of more importance to the public than all the property of all the rich men in the country. This idea was critical. Secrecy was not everything at the founding of the Republic in terms of the expectation of how courts would operate. So let's take a look in the 1800s at what was going on with the Supreme Court. And so we can look at the Missouri test oath cases. And there were pre-decision public disclosures of the outcome in those and other significant cases in the 1800s. And so we have these Ex parte Garland and Cummings v. Missouri from 1867. Basically, it's a situation where Missouri was looking to be a state after the Civil War, and the question of an oath provision that anyone who had been hostile to the government or given aid to enemies of the government would be disenfranchised was at issue. And that would obviously disenfranchise former Confederate soldiers. And so the constitutionality of this oath went up to the Supreme Court of the United States. And before a ruling was issued, Congressman Hogan told an audience in a speech that he'd been told firsthand by the court that the oath was going to be struck down. Other congressmen publicly did the same, papers published it, and eventually it came out that Justice Greer had leaked this. Now, this was not a one-off. The legal tender cases of 1871 and even Dred Scott in 1857 were also leaked pre-issuance. Some had some controversy about being leaked pre-issuance, but they were leaked. And this was a somewhat regular occurrence when you read the history of how some of these cases happened at the time, that perhaps to the parties at least, there'd be a pre-leak from the court in terms of what was happening. And so there was no custom or ethical rule at the time that expressly prohibited it. And so it goes to show that, at our republic's founding and in that first century, this idea of profound secrecy such that, an opinion is leaked, the sky is falling, wasn't really how the court operated in the 1800s. But let's get to the 1900s. And we're going to have a fun little look here at leaks starting from the 1960s and 70s when significant leaks started coming out of the Supreme Court. And we're going to look at this from Bob Woodward's fantastic book, Brethren. I'm sure you've all read it. If you haven't, that's my plug for Bob Woodward, not that he needs my plug. In any event, The Brethren is hilariously fun to read, but it's got massive detail based on leaks of interviews, including with justices, about how the Supreme Court was really operating. And so one of the funny ones you can look at is their famed movie day event, where you have the justices sitting around watching porn films to figure out whether they were obscene. And it's really absolutely hilarious. Just the very concept that, kind of 9 old white men in the 1960s and early 1970s are watching pornography to figure out, what pornography is for the nation as a whole, given, for all men, all women of all race, creed, color. I mean, it's just absolutely hilarious itself. But then within the four corners of what they were doing, you can see here some of the hilarious quotes in terms of what came out in terms of their own positions. And so you've got Justice White taking the position that there should be no erect penises, no intercourse, no oral or anal sodomy. For Justice White, no erections and no insertion meant no obscenity. Justice Brennan said there must be no erections. He was willing to accept penetration, however, as long as the pictures passed what his clerks referred to as the limp. You can see there, the limp standard. Oral sex was tolerable if there was no erection. Justice Stewart had the Casablanca test. I know it when I see it. And this came from his experience, apparently, when he was in Casablanca as a Navy lieutenant, and he'd seen men bring back locally produced pornography from Casablanca to the ship. And he said, so I guess Justice Stewart said he knew the difference between the hardest of hardcore and much came before him because he had seen it all in Casablanca. So these are leaks from the Supreme Court on kind of hilarious, but also significant stuff that's remarkably embarrassing, obviously, for the Supreme Court and the justices in terms of these things. But these leaks were occurring in the 1960s and 70s, showing that it's not unique. And so here we see on the next slide, this is from page 198 of The Brethren, which you can read, because this really is, absolutely priceless stuff if you actually read it. Because you've got, it starts here where, at Trader Jix, Justice Marshall had just launched into another story when he suddenly stopped. He stared at his watch a moment. It was about 1:50. My God, I almost forgot, he said in a stricken tone. It's movie day. We have to get back. And so this goes on to explain movie day court, where, they would figure out what was going on in the porn movies. And so you've got one of the funniest parts, I think, down at the bottom is You've got the others sat on folding chairs with their clerks, watching such films as I Am Curious projected onto a white wall. During his later years, Harlan watched the films from the first row, a few feet from the screen, only able to make out the general outlines. His clerk or another justice would describe the action. By Jove, Harlan would explain. Extraordinary. So you can just imagine what's going on. It's absolutely hilarious and priceless stuff, but these are, really significant leaks of a very, very personal nature about sexual stuff that were coming out and being published, which obviously created a whole range of then controversy, and Chief Justice Berger apparently was most upset about the book Brethren, but it was a set of leaks that came out and gave us some greater insight into what is going on at the Supreme Court. And on the other side of the table, from sort of like, should there be secrecy or not, we all got to learn the absurdity of what was going on when it came to trying to figure out obscenity with a bunch of these guys sitting around watching pornos. Just kind of silly way to sort of figure out a legal test, obviously. And so sort of a public service, I guess, shedding light on that, because I know it when I see it was abandoned. Now, we have more leaks, and this comes after the Bush v. Gore case, the significant case in 2000 that was 5-4 that ultimately stopped the recount and allowed President Bush to have Florida and then win the election. And a few years after 2000, in 2004, there were some really significant leaks from former law clerks that were published in Vanity Fair that created more controversy. And so you can see here some of these leaks that we're going to look at before we get to the leak of the reversal of Roe and start talking about whether it was illegal and what is the nature of secrecy and whether it's allowed. So here are some of the quotes that Vanity Fair got in terms of leaks, in terms of what was going on in those heady days of 2000 after the election, when everything was coming down fast and furious. We feel that something illegitimate was done with the court's power, and such an extraordinary situation justifies breaking an obligation would otherwise honor. Our secrecy was helping to shield some of those actions. That's a quote anonymously from one of the former law clerks explaining why their obligations of confidentiality that they've been sworn to, they felt they could break. We changed our minds every 5 minutes about whether the fix was in. Again, another anonymous clerk saying that, their perception at least, that the fix was in terms of how that decision was going to come down. Here you have another quote talking about Justice O'Connor's interactions with the decision. At a dinner on November 29th, attended by clerks from several chambers, an O'Connor clerk said that O'Connor was determined to overturn the Florida decision and she was merely looking for the grounds. And so that's a pretty remarkable leak and quote indicating that, true or not, we don't know, but at least one clerk was saying that Justice O'Connor simply wanted to overturn the Florida decision and didn't really know how to get there, but just wanted to get there one way or another. Another quote from a clerk, we feel that something illegitimate was done with the court's power, and such an extraordinary situation justifies breaking an obligation would otherwise honor. Again, referring and relating to this promise of confidentiality that law clerks agree to when they orally at least, when they join the court. Perhaps in a manual to an employment manual. So eager was the majority to stop the recount, one clerk recalls, that Stevens had to plead for more time to complete his dissent. Again, just sort of unseemly facts coming out in some sense, sort of painting a picture of what's really going on in the political nature of this. It's kind of like the Brethren 21st century, shifting from porn to voting rights. And then finally, at the conference following the oral argument, Kennedy joined the dissenters and at least temporarily turned them into the majority. The case would be sent back to the Florida court for fixing. The recount would continue. But the liberal clerks never believed that Kennedy had really switched and predicted that, having created the desired image of agonizing, he would quickly switch back. He probably wanted to think of himself as having wavered, one clerk speculates. And sure enough, within a half hour or so, he did switch back. And so there we see this kind of fact coming out, true or not, we don't know, about Justice Kennedy wavering, and as at least one clerk said, wavering because he liked the image of himself as sort of being undecided and not being partisan. So those leaks, you can read the fantastic Vanity Fair article, I think actually. It's a really good article. It's really fun to read. So you can go read that article there at that link if you want to learn more and see more about those leaks, which brings us to 2020s and the internal secrecy today. And we're going to come back to the Roe reversal leak. And we're going to look now at that case on the merits that we looked at before in our shadow docket segment. And so May 2, 2022, Politico posted a 98-page draft opinion from the Supreme Court reversing Roe v. Wade. This sent shockwaves through the press, the media, the legal world, of course, as we all remember. The Supreme Court immediately issued an order to its marshals to investigate the leak. No apparent hack was apparently found. Dozens of personnel were interviewed to see if they leaked it. Phones were even apparently either analyzed, or at least they tried to get a hold of people's cell phones to analyze to see if they could find traces of who did the leaking. But the question we're left with is, was it illegal? Now, it may have violated the Supreme Court's Human Resources Manual on confidentiality and law clerk canons, at least. Kind of this is a code of conduct of honor, at least among staff and law clerks, to maintain secrecy. Maybe even oral agreements of confidentiality law clerks have with the justices. The ultimate result, though, was that they were unable to identify the leaker, but we're left with this kind of important question about, okay, so let's say they leaked. So what? Was it illegal? Well, let's take a look at what happened. The Marshal of the Supreme Court issued a memo, and this memo argued ultimately that the leak could violate certain federal laws. And it's a fantastic memo, really. You should go look at it at that link I give you there, because you read it and, it's a stretch, in my opinion. So let's take a look at some of the laws that the Supreme Court's Marshal is saying may have been violated. We've got 18 U.S.C. 371, which prohibits conspiracy to commit an offense against the United States. Section 401 allows courts to punish contempt of its authority and misbehavior of officers in their official transactions. That sounds like contempt proceedings as against parties before it, not employees just kind of working in the court necessarily. 18 U.S.C. 641, I guess, the Supreme Court could try to get the U.S. Department of Justice to indict someone for disposing without authority of a record or thing of value to the U.S. Fascinating to see an indictment on that, I think, in terms of the troubles that would create and the real questions about that. We also have 18 U.S.C. 2071 that prohibits the unlawful removal of any record filed or deposited with any judicial officer of the United States. It seems like another stretch again. So the memo really reads as grasping at straws, candidly, in terms of trying to find some federal criminal laws that could theoretically give a hook to a prosecutor, if a prosecutor even cared, to try to go after someone and create more controversy and problems, probably. All of them look very, very thin. It looks like one of those memos you'd write as a summer law clerk or a first-year law student or a first-year lawyer desperately looking for any hook to justify a claim. The result, of course, is that now there are pending bills before Congress to actually make it illegal to have an unauthorized disclosure coming out of SCOTUS, and they provide for penalties for unauthorized disclosure of actual confidential information that would engraft upon Supreme Court employees. And that pending bill is out there. We'll see if it gets passed so that this kind of desperate grab bag of federal criminal laws isn't all that is at the hands of the Supreme Court or and then I guess the executive to prosecute, that actually have a more focused law that would actually make this a crime, thereby giving much greater secrecy to the Supreme Court and allowing the Supreme Court to imbue itself with this greater bubble of secrecy to prevent future leaks. Interestingly, this memo authored by the Marshal of the Supreme Court actually argues that consideration should be given to supporting such legislation, which I thought was particularly interesting coming from the Supreme Court, as it appears to be a bit of an advocacy piece from them asking Congress to support that kind of legislation. I thought it was particularly interesting because you see in other contexts when Congress asks the Supreme Court to come speak about, like for example, the ethics issues that are hot in the press in 2023 right now about kind of the ethics questions plaguing some of the justices about whether they should have recused or identified information and does that violate the law or not. The Supreme Court says, no, we're not going to come and speak to you about these things, separation of powers and all that. But when it runs the other way, they want laws passed to cocoon them in more secrecy so that future leaks don't happen. As a fun little aside, some people have talked about some of the technology they can employ, such as there is paper apparently that has nanoparticles in it that can be tracked so that alarms go off if the paper leaves sort of the premises and whatnot. It sounds like James Bond, Mission Impossible, and science fiction, but it's true. So I guess if you're a future law clerk, you should be very nervous about taking a piece of paper out of that building, because who knows if one of your justices has got these kind of secret particles in the paper that'll trigger an alarm. Now let's shift to cameras, recordings, in this world of secrecy. The current rule is that there is no photography or audio-video recording allowed inside the courtroom, subject to the audio broadcast the court allows itself to issue, but you can't record anything. In 2018, Justice Roberts said that our job is to carry out our role under the Constitution, to interpret it according to the rule of law, and I think having cameras in the courtroom would impede that. Now, that's where the Supreme Court stands, but when we look at the federal appellate courts, video and audio recordings of all arguments are generally available in most circuits. I mean, the Ninth Circuit's incredible. I've argued in the Ninth Circuit many times, dozens of times. And not only is there a video and an audio that you can get of your argument afterwards, the video is live streamed. Now, the Supreme Court allowed live audio feeds of oral arguments for the very first time during COVID. Until then, we couldn't actually listen in real time. And currently, even post-COVID, it still has audio feeds that can be listened to the day of the argument, as well as an offer of the video of the hearing transcript, but there is no video feed. Video feeds in the Supreme Court are still not there, even though they are there, for example, in appellate courts, and we don't seem to be having huge problems in the appellate courts in terms of misbehavior of lawyers or judges because they're on video. But nonetheless, the Supreme Court refuses to allow itself to be videoed, part of its world of secrecy. So let's take a quick look at courts and secrecy, and we're going to look at this case of Landmark versus Virginia from 1978 from the U.S. Supreme Court. And this is a case where there was a Virginia statute that made it a crime to divulge information regarding proceedings before a state judicial committee that was listening to complaints about judges' misconduct. A newspaper then printed an article accurately reporting on a pending inquiry into a judge in terms of this misconduct behavior, and the newspaper publisher was convicted of violating the statute. The Supreme Court held this violated the First Amendment. Major purpose of the First Amendment is to protect the free discussion of government affairs, which includes a discussion of the operation of the courts and judicial conduct. And the article published by the newspaper served the interest of public scrutiny into judicial misconduct matters. And so there is this idea that, look, the First Amendment stands out here and does not allow courts to shroud themselves in secrecy by, getting laws passed to allow judges, subject to misconduct, to stuff to kind of be buried and hidden. No. So the First Amendment is part of what's at play here in terms of defining some of the boundaries of this kind of secrecy bubble that the Supreme Court seems to be cocooning itself in. And so let's just take a quick look at the early Republic years to modern day in terms of the public access to court and the secrecy rules. In the earliest days of the Republic, the judges actually rode circuit and literally went to towns and cities to hear cases and issue decisions, and this gave the public kind of working insight into how the courts worked, because the judges were literally going town to town and deciding cases right there, among the people. In the 20th century, of course, we don't do that anymore, but we do have the case of Richmond Newspapers versus Virginia from the U.S. Supreme Court in 1980, where a judge had granted a criminal defendant's request to close the courtroom to the public after a series of mistrials. A newspaper sued, saying, no, the public has a right to access the trial court's proceedings. And you can listen here for about a minute and a half to Professor Tribe's oral argument arguing that this violates the First Amendment.
Mr. Tribe, you may proceed whenever you're ready.
Mr. Chief Justice, may it please the Court. This is an appeal by the Richmond newspapers and two of its reporters who were expelled, along with all other members of the public, from an entire murder trial in September of 1978. It was the fourth time that the defendant had been brought to trial for the murder of a local hotel manager, and his case had already been extensively described in the local press. On motion of defense counsel, without objection by the prosecutor, the trial judge closed the entire trial on the authority of a Virginia statute that gives trial courts discretion to treat all observers as, and I quote the language of the statute, persons whose presence would impair the conduct of a fair trial. At the end of a 2-day secret trial, the trial judge excused the jury, declared the defendant not guilty of murder, and set him free. On petitions for appeal, mandamus, and prohibition, appellants sought to prevent their recurring exclusion from complete criminal trials by urging the Supreme Court of Virginia to hold such closure unconstitutional.
There you have it. The Supreme Court held 7-1 that the press and the public have a First Amendment right of access to criminal trials to get information going on in the courts. The question that we're still left with, though, is can you video broadcast them? The Judicial Conference from the 1970s said no, they don't like the idea of courtrooms and cameras, and there would be a prohibition against broadcasting, televising, recording, etc., courtroom areas. Now, in the 1990s, this became discretionary for federal judges, and it's in a discretionary zone. Here's Justice Frankfurter talking about secrecy in the Supreme Court, which plays into this idea in terms of the limits at which we're going to allow video cameras in the Supreme Court, at least from the Supreme Court's perspective. The secrecy that envelopes the court's work is not due to love of secrecy or want of responsible regard for the claims of a democratic society to know how it's governed. That the Supreme Court should not be amenable to the forces of publicity to which the executive and the Congress are subjected is essential to the effective functioning of the court. This idea is what animates both the secrecy that prohibits leaks and the freak out that happens at the Supreme Court when leaks happen, but also even the idea that, they don't want to be videoed even. There's this sort of just secrecy idea that it is claimed at least is essential to the effective functioning of the court. Big open question, obviously, as to whether that's true. What about the public's right to attend appellate hearings? Well, we have 3 decisions here. We have one from the Fourth Circuit, one from the Ninth, and one from the Seventh, and all basically hold, and you can see the quote, I'll just read the first one. The First Amendment guarantees a right of access by the public to oral arguments in the appellate proceedings of the court. They've been historically open to the public, and the very considerations that counsel in favor of openness of criminal trials support a similar degree of openness in appellate proceedings. So you have a right to go watch appellate hearings because they are public hearings in public courts in a branch of our government. We have the right to watch them. This, of course, gets at the question of, why then there are video feeds so that the public who can't perhaps get to the court or there aren't enough seats in the court can watch it, which of course gets to the big question about the Supreme Court in terms of cameras and audio after COVID. Are we going to start demanding more access to the Supreme Court? So here you see as we're getting to the end of our program, that live broadcasting in the federal courts took off after the COVID pandemic. State Supreme Courts started allowing it too. 30 out of 50 now allow it. And indeed, in one case in Hawaii, hundreds of people logged on to watch a Supreme Court oral argument there over water rights from their state Supreme Court. Now, our U.S. Supreme Court, we have this historical problem where there's only 50 public seats. And so people sometimes have lined up for days to gain access to get a public seat. And as is well reported in the press, many times those people lining up are being paid by rich people, lobbyists or other rich people, to line up for days to get a ticket, and then the rich person or the lobbyist or whoever shows up and goes and takes the seat, having paid someone to line up. So there's this whole just unseemly thing about who's even getting these 50 public seats and how they're getting it. But with live audio broadcasts that the Supreme Court now started doing after the pandemic, we actually had situations where 100,000 people listened to some of the May 2020 audio feeds, and by the end of 2020, apparently over 200 million people had listened to at least one Supreme Court oral argument. So it goes to show the public wants to know and listen to what's going on in this court. It's important. Now let's take a quick look, though, at just as a little sidebar here on the flush-in time that embarrassed 9. And so we're going to listen to the 17-second link because this goes to show when courts are issuing audio and video feeds, they and you as lawyers should be very careful what's going on in your background noise. So listen to this 17-second YouTube or this 17-second clip from the embedded YouTube video on this link.
And what the FCC has said is that when the subject matter of the call ranges to the topics, then the call is transformed, and it's a call that would have been allowed and it's no longer allowed. And so I think that the content of the call is different here.
Excuse me. I guess the technical.
There you have it. One of those 9 flushed the toilet during the oral argument. The lawyer did a great job of going on and not saying anything or pausing. Someone was mightily embarrassed. Who knows who it was? Let's look now at a proposed bill after COVID, looking at reform. And this is the Cameras Courtroom Act. It was proposed in 2021. It didn't get out of the Judiciary Committee, but it's been renewed in 2023. It's got bipartisan support from senators on both sides of the aisle. You see them listed there. It's had support of the Government Accountability Office from a 2016 report saying that we need video broadcasts. And it's a very simple, very simple law. The law proposed would say the Supreme Court shall permit television coverage of all open sessions of the court unless the court decides by a majority vote that allowing such coverage would constitute a violation of the due process rights of one or more of the parties before the court. So it's basically, this stuff's got to be videoed unless there's a really big due process reason not to video and send it out. This is a significant pending bill, especially in our technology age, and there's clearly an appetite for people to be able to not just listen, but watch. And it raises a big question about why can't we watch the Supreme Court justices in action? We watch our appellate justices. And the arguments for and against it that get tossed out, of course, revolve around transparency. The counter is that, do we want to create judges as celebrities with like followers potentially? Are we going to have judges playing to the camera or even lawyers playing to the camera? Should there be comedy between the branches in terms of dictates on how they manage their proceedings? Does live audio give enough access? All of these questions are what's batted about. I would say, having done dozens and dozens of arguments in the Ninth Circuit, that I've never once seen a lawyer or a judge play to a video feed. Of course, the cases aren't necessarily the 70 scant cases that get big national attention that the Supreme Court gets, but nonetheless, it does seem that in the 21st century, the idea of a video that would actually let us see these 9 people, and in terms of their body language, in terms of their tone, their question, and just kind of our right to see them since they're the head of the third branch of government, does seem to be a significant issue. And it looks like at some point, given the bipartisan support, it may well be that we will have cameras in the Supreme Court. This brings us to our conclusions. Shadow docket to resolve cases. It's a controversial thing. It's both controversial outside the court and even inside the court, as you saw in those dissents. The use is definitely augmented significantly in recent years, which is why there have been hearings held in Congress, and there may well even be bills passed at some point to try to get some control over the use of this docket, because of the fact that it raises these transparency, complicated questions, regarding precedential value to lower courts. We also, post-COVID, see a new level of transparency afoot in terms of live feed of audio, at least, arguments from the Supreme Court. And with this technology, there's a greater need for sustained transparency coming, and it's possible to see changes coming in the future years that give the public as a whole greater access to video feeds, which of course controversial inside the court, but perhaps less controversial outside the court. The secrecy laws that allow the court to cocoon itself in secrecy too are potentially on the horizon to be enacted and passed, that would give the Supreme Court greater control over its internal workings and secrecy control, not relying just on custom and the fear of law clerks to being subjected to perhaps disciplinary proceedings or being outed for having done such a thing, but perhaps with positive laws that will be enacted to punish violators. And of course, we saw the Brethren Vanity Fair examples given, which I think are good examples I gave, because one can make a very strong argument that those leaks were critical to give us a proper understanding of what in fact is going on in the court. And so if the court is going to be allowed to cocoon itself through criminal secrecy laws and never allow those leaks to occur that give the public better, accurate insight into what's going on, it may actually do a great disservice to the justice system as a whole. And so, balancing this out, we saw a couple cases that deal with courts and secrecy rules that butt up against the First Amendment, and the idea that the First Amendment stands here and its principles are very important to put a limit both on the ability of judges to cocoon themselves in secrecy when they're being subjected to scrutiny for their behavior, but also trials in terms of what's going on and the limits that can be placed on them in terms of secrecy given the public's right to access. And although those cases came up in the 1970s and 80s where there was less ability to televise in a practical way, in this day and age with Zoom and a small webcam and the ability to broadcast it over the internet so that hundreds of millions of people could actually see what's happening, the arguments become more and more profound to justify that bipartisan bill we saw. Thank you very much for listening to this Curious Lawyer program. As always, if you have questions, please feel free to email me and check out our other fun, educational, interesting Curious Lawyer programs. Thank you.